The First District Court of Appeal is now in session. All who have business before this court, draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good afternoon. We have one case scheduled for oral argument this afternoon, the case of Justin Green versus Alachua County. We've allocated 15 minutes per side for the oral argument. Counsel, Mr. Childers, would you like to reserve some time for rebuttal?
Yes, Your Honor, I'll reserve 3 minutes.
So noted. You may proceed.
Thank you. Good afternoon, panel. Mr. Ross, I would like to wish everybody a happy and blessed Thanksgiving before I begin. Thank you very much for the time this afternoon and for the consideration of this matter. My name is Jeff Childers. I represent the appellant in this case, Justin Green. May it please the court. As a housekeeping matter with regard to the section 27.08 issue, I'm going to rest on the briefs except to say that it's black letter law that a more specific statute controls over any more general statute. So since section 27085 refers specifically to executive orders like the mask mandate, it must control over all more general statutes. I'd like to begin by talking about the essential holding below. And this is the holding that the government is asking you to affirm. The holding is, as described in the county's briefs, that citizens' constitutional rights end where the risk of transmission of disease begins. Neither the federal constitution nor our state constitution includes any risk of transmission exception. Neither the Bill of Rights nor the Declaration of Rights include a right not to become infected, as the court below explained it. Looking back a little bit in history, the Weimar Republic had a beautiful constitution. It was simple, it was elegant, it was based on the US Constitution. It had better and more protection for individual rights than our Constitution does. One classic example is that the Weimar Constitution had the right to vote for women a year before we got it here. But
Counsel, if I could interrupt, we've only got a few minutes here with you, and you could spend your time talking about that Constitution, but I think it might be better served looking at this particular case. And you've got 4 elements to the temporary injunction that you've got to overcome and persuade us that that's the case here, because it's a temporary injunction. If I could start with a question I have, the record doesn't seem to indicate much about Mr. Green at all. So I'm assuming what you have pursued is a facial challenge to the ordinance. In other words, there's nothing unique about Mr. Green. He isn't asserting, for example, that his religious tenets prohibit him from wearing a mask. He's just asserting overall, on behalf of essentially every citizen, I assume, in Alachua County, that the ordinance is unconstitutional.
that's correct. It's a facial challenge.
Okay, so if there's any one application of it that is constitutionally permissible, the facial challenge fails, correct?
I haven't considered it that broadly, Your Honor. I'm not prepared to answer that question. I'd be happy to provide a supplemental brief if the court would like.
Well, I think the answer to that is yes. If there's one constitutional application, then the facial challenge fails. So, I mean, that is the prevailing standard. So that's the one you've got to meet here, showing that it has no constitutional application whatsoever in any situation.
Your Honor, I think that the standard that we need to meet is to show that the mask mandate invades historically protected constitutional liberties. If it does, then the county is required to meet a strict scrutiny standard. And if they're required to meet a strict scrutiny standard, I could go through the elements. I think we're all very familiar with them. But the bottom line is that the county has to prove that its mask mandate is effective and necessary. I'm paraphrasing.
Well, it might be helpful if you could walk us through a specific real-life example of how the ordinance affects your client's well-established, historically rooted constitutional freedom.
Well, at the risk of redundancy to the briefs, where we spent an extensive amount of time discussing that particular issue. The mask mandate, number one, invades his likeness, right, which has historically been recognized as a property interest, as a valuable commodity even. It's protected in Florida statute and I believe constitutionally. The mask mandate interferes with speech. It interferes with speech literally interferes with speech. It conveys a message that the county wishes for the citizens to communicate. Commissioner Hutchison described it as a signal that a citizen is part of the solution and not part of the problem. The mask mandate is rooted in an awful historical legacy. The Seventh Circuit described allowing citizens to wear masks into courtrooms as the worst thing the court could possibly do, the most reckless thing the court could do. I can't remember the exact language. You may recall it.
Oh yeah, but those situations didn't involve a pandemic. I mean, it's one thing to wear a mask into a convenience store and commit a robbery pre-pandemic. It's another thing during the pandemic to say, well, I have to wear a mask now, so therefore I'm going to be mistaken for a criminal.
Well, I think you're reaching the issue of whether there's a pandemic exception to the Constitution. And that's what I was getting at earlier.
Yeah, well, there's certainly a public health interest, isn't there?
Give me 2 more seconds to finish where I was going. I think I'll get there. So that Constitution I was referring to, which is not our Constitution, had a fatal flaw. The fatal flaw was Article 48, the emergency powers section. Historically, it only lasted 20 years because that emergency powers exception ultimately swallowed the entire Constitution. That's what they're asking you to affirm here under the guise of, general police powers, the health and welfare of the community, and so forth. They're asking you to say, well, if there's a pandemic, if there's a legitimate potential application for the government to exercise police powers on behalf of the health and welfare of all of us, then that trumps constitutional liberties. And that is the Article 48 for our Constitution. It's not in there. We don't have that. That's why our Constitution has lasted as long as it has. If you affirm the opinion below, you will give the government an Article 48 loophole, because the government defines when the emergency begins and when the emergency ends. It defines the scope of the emergency, and it's provided a criteria for you to consider this risk of transmission of disease. It defines what a risk of transmission of disease is.
Well, counsel, I'm struggling to understand. You don't want the government to have the ability to take action in wartime and pandemic time. Explain to me. I'm trying to get a grasp of the constitutional principle you want us to understand.
So the question, Your Honor, goes to what the issue of this case is. And the issue of this case is not, you don't have to decide whether masks should be banned or mask mandates should be allowed. That's not the issue today. The only issue is, does the government need to show that the masks are effective? If this mask, this covering of every citizen's face, invades historically constitutionally protected areas, the county may yet succeed in ordering it. It just needs to meet strict scrutiny. That's the only issue that we have to decide. Is the county required to meet that standard?
Well, what expressive activity that your client or anyone else, I guess you're trying to say in every instance there's an expressive element. I understand when you have a mask on, people can't see you smile. They can't see maybe whether your total facial expression. They certainly can still see your eyes. They can still see your entire physical presence and so forth. But what expressive activity in these limited circumstances, when you go into to the grocery store, when you're going on a public bus, I mean, what is it that is being infringed upon in your view?
Well, picking up on your point, they don't call them facial expressions for nothing. And we cited the Colorado Supreme Court that defined the facial expression as a core element of communication. and necessary for all normal communications. So let's not write that one off too quickly. But let me ask you this. If the county's purpose is to protect the population from the risk of transmission of disease, then why can the county fine or arrest someone who is not wearing a mask but is not capable of transmitting the disease because they're negative for that disease, or they've already had it, or they've had a vaccine, or for some other reason? So for example, let's say you go to Publix, you're not wearing your mask, you're fined or arrested. Why can you not defend yourself by going and getting a test that shows that you're negative for virus? It's
Well,
impossible for you.
I thought that the science shows that you could test negative, still have it for a length of time and be communicable. That the test is, I mean, do you have testing on a daily basis in Alachua County? I'm not sure.
So let's say I don't know that I necessarily agree with that description of the science, but even if that were true, you could take your test 2 days later, right? Or 6 days later. And if you're still negative, then you didn't have it on the day you weren't wearing your mask.
But how did you know on the day you weren't wearing your mask that you didn't have it?
What difference does that make? It was impossible for you to commit the offense. You can't commit that offense of increasing the risk of transmission of disease if you don't have it. It doesn't matter whether you know it or not. So you should be able to defend yourself from a violation of the mask mandate by proving you were incapable of committing the offense, but you cannot do that.
Well, maybe there is defense, or I don't know. I don't see where that necessarily makes it unconstitutional on its face.
It's irrational. The mask mandate, not only does it not provide a way for you to defend yourself, it assumes that you're guilty until you are proven innocent, but you can't prove that you're innocent.
I recognize there's fines here. It's a non-criminal sanction, but it still obviously has significant non-criminal penalties or non-criminal fines. I understand that.
And in addition to that, the mask mandate explicitly exempts persons who have difficulty breathing, which would include persons who have COVID-19. So the mask mandate allows people who are sick not to wear a mask, but people who are healthy and could not possibly commit the offense, even if they wanted to, they must wear the mask or be fined or potentially incarcerated under the state statute. In my reply at the end, I asked the question, would you consider a permanent mask mandate to be unconstitutional? If a permanent mask mandate would be unconstitutional, then a temporary mask mandate must at some level invade constitutional issues for the same reason.
Counsel, in your legal research, did you find any authority, either trial or appellate case law, declaring mask mandates unlawful?
I've never found any case law relating to mask mandates on a health basis. Now, there's a lot of case law talking about mask laws related to the wearing of masks, quite a bit of it. And every one of them has observed that masks have a terrible communicative legacy. They communicate themes of violence and intimidation. Court after court after court has said that.
Yeah, but we're not talking about like a Ku Klux Klan mask here.
I didn't quote any Ku Klux Klan cases for that reason. I've got cases in my briefs as late as 2017, have nothing to do with the Klan. It's universal throughout the United States. It's universal throughout the world. That is, countries that never had a Klan have problems with face masking. Now, in my initial brief, we predicted, based on what the courts were saying about masks, that we would have a problem with encouraging crime. And that's exactly what we saw through the summertime. The Georgia Supreme Court said that the mask calms the criminal's inwardly fear and emboldens him. And we saw outbreaks of violent crime across this country like we've never seen before. And there's one thing in common with all of those folks is that they were wearing masks at the time. I'd like to just touch on the minor inconvenience argument because the county's brief uses that phrase a dozen times. Convenience is a subjective term. I don't know how you measure it. I wouldn't know how you prove whether something was a minor inconvenience or not. I think that the evidence, the anecdotal evidence certainly suggests that a lot of people don't seem to view it as a minor inconvenience. They're going to jail, they're getting fines and citations and so forth. But
that's a result of not wearing the mask. I thought the inconvenience you were referring to is the inconvenience of wearing the mask.
well, right, but clearly if it were only a minor inconvenience, I doubt someone would be willing to go to jail in order to avoid complying. But let me read this to you from Reed versus Covert, 354 US 1. The Supreme Court said it's urged that the invasion of rights claimed here is only slight, and that the practical necessity for it is very great. The attitude appears to be that a slight encroachment on the Bill of Rights and other safeguards in the Constitution need cause little concern. Slight encroachments create new boundaries from which legions of power can seek new territory to capture. It may be that it's the obnoxious thing in its mildest and least repulsive form, but illegitimate and unconstitutional practices get their first footing in that way, namely by silent approaches and slight deviations from legal modes of procedure. This can only be obviated by adhering to the rule that the constitutional provisions for the security of person and property should be liberally construed.
Counsel, the respective parties cite the U.S. Supreme Court's opinion in Jacobson versus Commonwealth of Massachusetts. There, the Supreme Court decision basically instructs that all constitutional rights may be reasonably restricted to combat a public health emergency. I think that case involved the wearing of a mask, required vaccines. Would you agree that requiring vaccines is more intrusive than a mask mandate?
Your Honor, I haven't studied the vaccine issue, but I would say this about Jacobson. First of all, I would refer you to two cases that discuss it much more eloquently than I can, the Bailey's Campground case and the County of Butler case. Both judges who are much smarter than I am spend a couple pages analyzing that Jacobson case. But the bottom line is it's a 130-year-old case that was decided before the Supreme Court created the three levels of scrutiny that we have today for analyzing constitutional rights. Most constitutional scholars believe that Jacobson was, to the extent it was a standard, was replaced by subsequent years of civil rights jurisprudence from the Supreme Court. And I see I'm into my time, so I'll stop unless the panel has questions.
My question was, would you agree that requiring citizens to be vaccinated is more intrusive than a mask mandate?
I don't know if I can agree with that, Your Honor. I mean, arguing that, making the devil's advocate argument, the vaccine is something that happens one time. This mask mandate appears to be a permanent requirement that all citizens cover their faces in public.
But how can it be
forever?
How can it be permanent? There's no, the order has to be revisited every 7 days. It can change over time. It's not a permanent. I mean, if the ordinance says you have to wear it for the rest of your life, yeah, you'd be right. That's permanent as to that person. But you keep saying these words like permanent. I don't see where it's permanent.
Well, I don't want to quibble about semantics, but
what's your word? It's not mine. You're saying it's a permanent mandate. I don't understand where you're getting that.
Well, in my view, something is permanent is something that has no end. The county has not announced any end. It routinely now 30, 40 times has extended this 7-day period that it was previously restricted to for emergency orders and goes on and on. County commissioners here in Alachua County are talking about maybe being the end of 2021 before they're willing to consider relieving the mask mandate. It doesn't seem, I don't know, maybe it's not permanent, but it's not temporary.
Thank you, Counsel. Your time has more than expired. However, I'll allow you an additional 2 minutes for rebuttal. and we'll extend counsel for the appellee's time by an additional 2 minutes. Thank you.
Good afternoon. May it please the court. My name is Jack Ross. I'm here on behalf of the appellee, Alachua County. I would tell the court, for reasons which only my private computer devils can explain, I cannot see the clock on the screen. I am trying to keep track of my on my watch, but if I go over, I apologize. The substantive issue that is before this court is whether the federal and/or the state constitution prohibits the citizens of Alachua County through their elected representatives from adopting reasonable regulations to restrict the spread of a deadly disease. Procedurally, we're here on appeal of the denial of a motion for temporary injunction. Now, we all know what the 4 elements that the appellant was required to prove in order to obtain a temporary injunction. The first is the likelihood of success on the merit. I intend to address all 4 times.
Well, counsel, you've got limited time as well. I have a question as to the substantial likelihood of success.
Yes, sir.
One of the, I think the first count in their complaint was that you lacked authority, and they cited to the Alachua County Charter. I think it was chapter 27, if I recall correctly. And I don't see where the trial judge addressed the issue of the county's authority under the charter in its order. It addressed the privacy issue and concluded that there was no privacy interest when one goes out to a store, rides public transportation, and so forth. You're opening yourself up to go into the public. People can observe you and so forth. So the trial judge basically said there's no privacy interest here that had to be regulated according to the according to the compelling interest test. What about the issue of the county's authority under its own governing document?
Your Honor, my memory is that the court did address that issue, but the authority does fall under 28.071D, which gives the county in an emergency situation the authority to regulate and or close down businesses, places of entertainment, and public places. Now, the concept of regulating, even to the extent of closing down, is certainly broad enough to include authorization to require people who are using those places, those public places, to wear a cloth or paper covering.
Okay, so your argument is that if we have the authority, meaning the county, we have the authority to shut down a bar or a restaurant, then we can certainly do something less than that and just regulate the facial wear of the patrons that go there.
That's exactly right, Your Honor. In fact, the statute or the ordinance says it has the right to regulate or close. And I think that if it has the right to close, certainly the regulation would fall in, and certainly the covering of one's mouth and nose would fall into a lesser category than closing.
Okay, if I could ask another question. As I understand the situation, you meaning the county again, have to every 7 days make another assessment about the viability of your order. Basically, if circumstances change one way or the other, you can adjust your order accordingly. Is that correct?
That is absolutely correct, Your Honor. And there's more. In addition to being renewed every 7 days, there must be a report every 30 days of what the status is and how it's being met, and whether or not the requirement goes. So there's the requirement not only for renewal every 7 days, but for reporting every 30 days.
Council, let me ask you a question about the Florida Constitution's right of privacy. Do you believe that that the Florida Constitution's right of privacy protects an individual citizen's right, at least to some extent, to make their own decisions about what they wear about their head and face?
Your Honor, I can envision a situation in which theoretically a government might require someone to wear something or not wear something. For instance, I can envision a situation in which if the government sought to prohibit eyeglasses, that folks with poor vision would have a justification.
Well, let me ask you this in a slightly different way then. So if the county commission decided in their judgment that they wanted to prohibit or they wanted to require people in Alachua County to wear a face covering hijab, would there be any constitutional implications from that?
I think there would certainly be constitutional implications for two reasons. One is, I think it would depend on the motivation and what the situation was as to whether it would be permissible or not. The hijab is generally limited to women. I think there would be legitimate equal protection issues there. And I think there would be legitimate religious or First Amendment rejection or issues.
So I'm asking you to set those things aside and I'm asking about Section 23 of Article 1 of the Florida Constitution, the right of privacy. Does an individual have the ability to make a decision on their own about what they wear around their head and face without government interference?
I think there might, Your Honor, I think there might be some right. I do not think that right is absolute. And I think it depends on the situation and what the basis and the reason for the ruling is. In this case, the reason is to stop the spread of a medical emergency.
Right. So we might turn our attention then to a subsequent analysis about whether or not there's a compelling state interest and whether or not the county is going about it in the least restrictive way. And so we might ultimately determine that they can or can't compel people to wear a face covering hijab. But certainly it sounds like you're agreeing there's at least preliminarily a constitutional right that is appropriate for the court to analyze under that test.
Your Honor, I think that the county could not require just on a whim all citizens to dress in any particular way.
Unless they have a compelling state interest and if they do, they're going about it in the least restrictive means.
I do not necessarily agree with Your Honor that all requirements of apparel reach the level of strict scrutiny. I would suggest that if there is a reason for the requirement that is rational, particularly if it is a short-term requirement, temporary requirement as we have here, that the county commission's judgment should be respected. As Justice Roberts said, in the South Bay case, the health and safety of the citizens is primarily entrusted to its elected representatives. And where the issue is fraught with medical and scientific uncertainty, that discretion must be extremely broad. And that's what we have here. We clearly have a medical emergency which is fraught with scientific and medical uncertainty. The facts change every day. The science changes every day. I read just today a study that was released on Friday from Kansas, which found that in counties which imposed a mask mandate between June 1st and the middle of August, cases had dropped by 6%. And in counties which had not imposed the mask mandate, they had gone up during that period of time by 100%. That's the kind of day-to-day decision-making that has to be made in this particular situation. It is fraught with medical and scientific uncertainty. The courts are not in a position to make those determinations on a day-to-day basis the way the elected representatives of the people are. That was the basis for Justice Roberts' conclusion that the latitude of the elected representatives must be extremely broad. I'd like to address an issue that was raised by Judge Lewis during the appellant's argument about the Jacobson case. Jacobson involved permission for the state to require vaccinations. Now, surely, if a communicable disease justifies the state in requiring an individual to puncture the skin and inject a foreign body into a foreign substance into his body, that is a significantly more extreme violation of individuality than the requirement to wear a face covering.
Counsel, let me ask you one more question. Just turning back for a second to the nature of my questions. So let's assume for a moment that, again, under the Florida Constitution, that we're at the point in the analysis where the burden of proof is shifted to the state, that is you, the county, in demonstrating that you have a compelling state interest and you've used the least restrictive means. Do you believe that you've met that standard?
I do, Your Honor, under the state of the science as it exists today.
Well, under the record evidence that's before this court, do you believe you've met that?
I do, Your Honor.
All right, can you tell me why and how?
Why? Because there is a substantial amount of evidence in the record before this court that masks retard the spread of disease. And there is a substantial amount of evidence in the record before this court that this is a medical emergency, that if we do not address it, it will continue to grow and it will continue to spread. And I think that history has shown that since Judge Keim entered her order. We have seen a tremendous variation in the outgrowth or the spread of this disease from one locality to another. And that there are behavioral changes, such as wearing a mask, such as social distancing, all of which have been supported by the Centers for Disease Control, who are the real experts in this matter. There is substantial evidence that in areas where those are adhered to, the disease is less widespread, and that in areas where they are not adhered to, the disease spreads. So there is a substantial amount of evidence, both in the record and since this hearing, that that mask and similar restrictions work. And it's
If I could ask a question, I know you're running out of time. Mr. Childers raised the point I wanted you to address, which he was saying, well, gosh, I could get my client tested and show I don't have COVID-19. Why can't I show a test a few days later to show at the time I didn't have my mask, I didn't have COVID-19? Could you respond to those arguments? I mean, he's really essentially getting at, is there another way of going about this versus a across the board sort of ban, with some exceptions, obviously. You don't have to wear it at night when you're at home sleeping and when you're with your family and so forth, obviously. But what about the things he's proposed as perhaps chipping away at what the county has done?
Well, Your Honor, let me point out that since this order that is currently before the record, again, things are changing daily. The government has issued an order that prohibits the imposition of fines for a violation of the mask order, permits the mask order, but prohibits the imposition of fines. So that issue is actually moot. But I would say that when you're dealing with a county that has 260,000 people, the lines don't need to be drawn exactly. That it is not practical by any stretch of the imagination to have a hearing on whether each person not wearing a mask tested positive or negative at that time. The only way Mr. Green could possibly know whether he had COVID on June 17th is if he had a test on June 17th. A test on June 18th doesn't do it because the virus depletes itself. A test on June 15th doesn't do it because the virus can be obtained overnight. So I don't believe that's a practical way to go about things, nor do I believe that we should place those kinds of restrictions in a situation like Justice Roberts says, which is fraught with medical and scientific uncertainty. I would like to address one more thing that I was struck by something that Mr. Childers said, and he talked about how the Seventh Circuit said it would be unheard of for someone to wear a mask in court. And I was struck by, I believe it was Judge Makar's question about that, because that depends on the situation. Because today, one is not allowed to walk into court without a mask by order of Chief Justice Kennedy. This is a new world. We are facing something that we have not faced before.
Counsel, as a follow-up question to Judge Long's question, you referred to this matter as a public health crisis.
Yes, sir.
When confronted with a public health crisis, such as this pandemic, may our elected officials implement emergency measures that curtail constitutional rights?
I believe that is a very limited yes, Your Honor. I do not believe that all constitutional rights are absolute without regard to the situation. Although certainly there would be a substantial justification that would be required in that if we were talking about real constitutional rights. I think the key issue here is that the appellant has not established any constitutional rights. The closest he's come is the right of substantive due process for autonomy and the right of privacy. But as the Fourth District said, the right of privacy has not made each individual a slopacistic island to itself. And I was driven to the dictionary to find that slopacistic means extremely egotistical. The right of privacy has been held to involve such rights as the rights whether or not to carry a child, the decisions on how to raise that child, decisions with regard to invasive treatment. The case involved a required cesarean section where a woman was ordered to be sliced open and her baby removed. Those rights are limited to the rights that are historically rooted in our notions of freedom, objectively deeply rooted in the nation's history and tradition. The right to show one's face when going in public does not simply reach that level. I'd like to talk about one other issue, one other element of the requirements for a temporary injunction, and that's the public.
Counsel, your time is more than expired. However, we will allow you to wrap up.
Thank you, Your Honor. I do not believe that requiring the county to allow its citizens to go about without protecting one another with a mask could possibly be involved in the public welfare. I want to conclude with some citations to a poem by the poet John Donne, when he said, "No man is an island. We are each part of the continent, all part of the main. The Constitution does not require every person for him or herself in the face of a medical emergency." Mr. Donne concludes, "Sin not for whom the bell tolls. The bell tolls for thee." We've had 257,000 bells toll nationwide and almost 20,000 in Florida. The county is entitled to issue reasonable regulations in an attempt to quiet those bells. Judge Keim was right. There is no recognized constitutional right not to wear a facial covering in public locations to prevent a contagious and potentially lethal virus during a declared emergency. I ask that that order be affirmed, and I thank you very much.
Thank you, counsel. Mr. Childers, the floor is yours.
Thank you, Your Honor. There's a common analogy that we're all familiar with that can help us understand whether we're still in an emergency 9 months later. Do emergencies last for 9 months? If something bad happens to you, you fall off a ladder, you have a heart attack, a stroke, something like that, they take you to a special room at the hospital called the emergency room. That's where you're in emergency. You don't stay in the emergency room. They either send you home with a prescription and or a cast or a Band-Aid, or they admit you into the hospital where you're treated in the normal flow with the other patients. What gets you out of the emergency room is when you've been stabilized. That's when you're not an emergency anymore. We've been going 9 months on this COVID experiment in our civil liberties. Justice Alito gave a talk at the Federalist Society 2 weeks ago. You could most fairly characterize that as a warning. He warned of
Well, counsel, I think we can pull that up and look at it, and I'm sure it's been around. Judge Long raised an important point, and Judge Lewis raised an important question, which was that under Article 1, Section 23, we all have a constitutional liberty to be free and let alone from governmental intrusion into our private lives, correct?
Apparently, except if you're a risk of transmitting disease to someone or possibly not.
I assume the answer is yes, because that's what the Constitution says.
Correct.
Then the next question is, what is the judicial test to apply when that right is subject to regulation? here you say that your client's rights and those of all others in Alachua County, that that requires a compelling governmental interest of the least restrictive means, correct? To infringe upon that constitutional right.
Your Honor, that's the standard that the court applied in Florida Board of Bar Examiners cited by the county, which involved a request by the bar for very personal and private medical information of the applicant. And they analyzed the right of privacy and considered what the standard should be, and they ultimately applied the strict scrutiny standard.
So for example, if the county required that someone who actually had COVID-19 put a big red dot on their mask when they walk around in public places, that decision would probably have some importance, wouldn't it? The scarlet
Yes.
letter, so to speak,
If I understand where you're going with that, sure.
because that discloses the person's medical status. But wearing a mask, the mask ordinance doesn't require the disclosure of medical status.
Your Honor, the mask mandate requires you to disclose your medical condition if you have an exception to the mask mandate. Right now. Explicitly. And I agree, that's unconstitutional. Yet another reason why the mask mandate should not be affirmed by this court.
Did you make that? I don't think you made that argument below, though.
I did make the argument below, and it's preserved in the briefs.
Okay, we'll check. Thank you.
The founding documents established 3 fundamental principles that we all live by and agree to, and there's no disagreement about them. Those are
Again, counsel, your time has also expired on rebuttal. I will allow you 1 minute to wrap up.
Thank you. Those 3 principles are life, liberty, and the pursuit of happiness. What we've done here is we've prioritized life over the other 2 principles. And you can make that argument, right? You can say life is a sine qua non of the other 2 principles. You can't pursue happiness if you're dead. You can't enjoy liberty if you're in the ground. But that's not what it means. The founders would say that life without liberty is not worth living. And life without being able to pursue happiness isn't worth living. You cannot prioritize one of those over the others without throwing the entire system out of whack. And I would implore the panel not to create an Article 48 loophole to our Constitution, but to reverse the order below and remand with instructions to enjoin the mask mandate. Thank you.
And thank you, counsels, for your respective oral arguments this afternoon. This concludes our oral arguments for this afternoon. We stand adjourned.